Alcohol-related accidents, social host liability rules and dram shop laws in New York. In New York, as in every state, there are specific laws that allow injured people to seek compensation when they have been involved in a car accident that was caused by someone else. When there is alcohol involved in the accident, there are laws in a few states that let the injured person seek compensation from a business or person who is known in the case as a third party. This third party would have had to provide alcohol to the individual who caused the accident. Claims filed against a business as known as dram shop laws. Social host liability and dram shop claims. Under Sections 11 to 100 and 11 to 101 of the New York General Obligations Law, social host liability and dram shop laws cover alcohol-related accidents. Section 11 to 100 details liability, and involves an intoxicated minor, whereas Section 11 to 101 details an individual or vendor who has provided the person with alcohol illegally. In cases such as these, someone who has been injured can bring a claim against the business or individual who provided the alcohol. They can only do this if the host or vendor knowingly caused the individual to become intoxicated or impaired by providing alcohol unlawfully. A claim can also be brought about if the host or vendor knowingly caused the individual to become intoxicated or impaired by providing alcohol unlawfully if they thought or were aware that the individual they were supplying the alcohol to was under the age of 21. In New York, if the intoxicated person was over the age of 21 and the alcohol was legally provided, the host or vendor cannot be found liable. This is the case even if the person who drank the alcohol caused a car accident and subsequently injured another person. Time limits and damages. A claim will need to be filed within 3 years of the date of the injury. If a claim is filed against a vendor or host within that period of time, then the case will be considered by New York's court. If it has been more than 3 years since the date of the injury, the statute of limitations states that the case will be dismissed. Some of the damages that are typically sought in car accidents that involve alcohol include the defendant having to pay for loss of earnings, pain and suffering, medical bills, lost or damaged property. If you have been involved in a car accident that was alcohol-related, or you served or provided someone with alcohol and they were subsequently involved in a car accident, you will need to speak to a lawyer as soon as you can.